G'day, Nina. How are you?
Good, thanks, Andrew. How are
Were
you?
you here last week?
No, I've not been back since I had to do it by myself.
Oh, that's right. You've had a pretty easy life in the last 2 weeks. About time we changed that.
It was 1 week.
Now, look, we're going to talk about a lot because a lot has happened today, but I do think we've had alarmist paradise out there. We've had groups of
Chicken
people.
Little effect.
Yeah, we have had the Chicken Little effect, and we've also had the favourite simpletons who go and tell stories which have a nice narrative that are not true either. So we've had the right to disconnect as some terrible thing that's happening. We'll talk about that later, but that's absolute bullshit. We've had people go on about the CFMEU like we all didn't know it.
Yeah, it's pretty much
It's a pile on now, isn't it? Everyone's there saying how brave, how wrong this is. But they were very quiet during the last DA negotiations, where 20% was growing on wage base. And then, of course, the last one is the usual nonsense about contractors and taking a common law case and seeking to extrapolate into safety law and actually not even getting the case right. So part of today is a demystification process of just telling some truths so people don't get lost in the long grass and believe popular narratives and get scared and don't know where to go home to. This is all pretty straightforward stuff. And we're going to start off with one of the more sort of interesting cases on that, which is a safety case.
Safety and privacy.
Yeah,
well, it's actually a privacy case.
It's a privacy case, and privacy has an exception around safety. It involved a person who suffered an injury in the business, told the business the person's name and the nature of the injuries.
Yes, but it was very public. It wasn't something that happened in the private. Like, they collapsed in the car park and 7 other employees had to help them out. And so they sent information that they've received from the husband with all the personal details of the employee and the husband to 150 employees.
Yeah, not a wise thing to do.
But in the interest of making sure that everyone knew.
So let's use, when you look at our book on safety, one of the things we say is to get permission from the family or the individual involved to make a disclosure to prevent the usual nong you've got in your group going and making up a whole lot of lies about someone. And remember, that's human nature, but also to provide some comfort to those who work directly, that the person is safe, is being cared for, and there's a level of disclosure which is succinct, not going down into individual treatments, but to provide a sense of safety to those people because they're scared, and to look at the broader community with a health and safety alert, and to the extent the person is known and respected, to make sure that people have this level of comfort that you as an organisation are engaged, and that you're doing the right thing, and that you're providing the only safe source. And most importantly, you're telling everyone, don't contact the family because they're already incredibly distressed by what has occurred. Now, you don't often get the safety commissioner out of bed, I've got to tell you. Privacy commissioner out of bed, yeah. Very, very, very quiet little place. Nothing ever happens. This was a $3,000 fine, and I suspect the commission doesn't.
To the employer.
To the employer, but this is a mistake. It was erroneous. It was done for the right reason. A $3,000 fine reflects that they had to do something, but also that the employer was trying to do the right thing. As Nina has said, there is a wrong thing in this, and that is the disclosure of information to people who don't need to know things that are private to a person.
Yes, like some people didn't even know about the employee's existence.
But come back to it, in a serious incident, get the family or the individual sign off for the nature of the disclosure, to give them a comfort, and advise your audience they are not to contact the family because the family don't cope with it.
Yeah.
So look, a case that agitates some really important issues, and it's a reminder to us all, particularly in Victoria with the Health Records Act, which there's 2 others in other jurisdictions. The disclosure of some of this information in Victoria would be a much more serious prosecution. Okay, let's jump on to our next case. Yeah, Safe Work New South Wales and ACON. Yeah, interesting contractor case, although it never happens. So for those people who say, no, principal can't be liable for a contract. Well, here they've been charged with a Category 1 offence.
Are you? Yeah.
You know, ACON is the principal here. The contractor was the person who got injured. Okay, subcontractor.
Yes.
Fell off a roof or something. Didn't know. I forgot what they did now.
Yeah.
Fell off a roof. And there's this case. No one's arguing this isn't a contractor, a principal liability case. By the way, just in case anyone missed it, no one's arguing that because that would be bullshit. The argument here is that there are a number of charges that have been laid based on the same set of facts, and there is a legal term called duplicity, which says you cannot allege the same offence in 3 different guises or 2 or 3 different guises. That is where you allege, based on the same principles of law, a similar issue, not where different pieces of law on the same set of facts are a breach.
Yeah.
So I know that's a highly technical thing, but often for those of you who will be charged every now and again, you'll find that you have a charge sheet.
That's so repetitive.
They're so repetitive. Often there is this vice of duplicity, which is where they've not only got the same set of facts, but they've got the same mental state that's involved in the same part of it, which is duplicitous. We're just putting this case on, really, this is me being naughty to show what absolute bloody nonsense the issue about contractor liability is, but also to show that at the moment the regulators are laying multiple charges, and just because they deal with the same set of facts doesn't make them bad. That's why I've got it here.
But it was such a weird argument. So basically, they were charged under Section 31, and there are two fault elements it could be under:
Negligence or recklessness.
gross negligence, yeah, or recklessness. And so ACON said, well, because it's two fault elements, it's actually two offences, so it's duplicitous.
Yeah.
But that's not how it works.
No, that's not how it works. Anyway, we won't criticise them too much for that, will we?
Yeah, but that's basically the case.
Anyway,
yeah.
So the answer is same set of facts, different element. You can charge differently.
Yeah,
okay?
But you can't have two different sets of facts to have the same offence.
Same offence, yep. All right, so why don't we jump to our next one, which you'll be surprised to learn is a principal and contractor case. Why am I doing this? This is I forgot the name of them are. They're the strata agent. What are they called? What's their correct name?
I thought it was.
Anyway,
no, I don't know. I don't have it.
So this is a property for which there is common property, which is managed by Bonus Corporation, and there were gates, and the gates were faulty and caused fatality.
Yeah, because someone drove a van into the gate.
Well, they did do that.
So it wasn't in the, what are they called, rollers?
Yeah.
And no one fixed it. They just left it there, and then it fell on someone as they tried to move it. Yeah.
So the answer was it sat in a common area, which is an area which everyone uses, which is unquestionably the common owner's property.
Yeah, because it was the entrance to everything. Yeah.
The injury was to somebody who was part of the other properties, and the answer is who had the liability. And there's absolutely no doubt that the common owner, whatever it's called, had a liability because it was on their part of the property for which they shared with everybody else.
Yeah, and they're responsible for the entries and exits.
But I want to just add this. There is also abundance law, and we are still involved, although distantly, in a case in Western Australia where when somebody who is an owner or a principal is aware of a risk that exists in some other part of a property for which they don't have immediate control, their awareness of that risk to other people becomes a potential liability for them. So the principal contractor thing at common law and at safety law is always, although it's much easier to breach in safety than common law, where someone has a knowledge of a known liability for which they are an owner and they do nothing about it, then they will attract liability at common law, and in safety law there's absolutely no doubt they will attract that level of liability. So I'm just putting these cases in because we're getting to the case that I really want to talk about, which is Sawyer. This was a really straightforward case of a principal builder who delegated quite clearly in a contract the responsibility of concreting to a specialised concreter. And although the principal did some contracting, they didn't have the specialised knowledge that related to this. And that is incredibly important, okay? That difference of knowledge and the precision in which it was given to someone who had specific knowledge meant that when somebody was injured and a guy hurt his back lifting up and down some steel...
Concrete slabs. Concrete sheets, sorry.
Concrete. It was actually the steel within it, which was 120, did his backing. There was an argument that was run that the principal had a liability around it.
Yeah, like that they breached their duty of care to him.
Yeah. And the case found what we've all known for a long period of time. In negligence law, there are a fixed set of recognised duties, like the employer duty to an employee. There is no recognised duty of a principal to the employee of a contractor. But that does not mean, I just want to say this very slowly, that does not mean they will not be liable to an injury that arises to an employee of a contractor where that person arose from a known hazard and risk which the principal was aware of.
Yeah.
Okay? So can we stop this bullshit that there is
that you can't contract?
that there is no duty. It is not that there is no duty. There is no recognised duty. You then fall back into general principles of negligence. Now, can I say to you, in safety law, the knowledge that you do some contracting and someone's picking up a great big pieces of iron, under safety law, the risks of prosecution of the principal in this case were actually much higher, because common sense would say if you see someone lifting large pieces of metal around the place, which are more than 50 kilograms, they could hurt themselves. So can I just say to you, safety law, particularly in Victoria, but with the PCBU definitions everywhere else, makes it very clear that the definition of worker includes the worker of an independent contractor, and the words engage in Victoria extend that definition. So it is absolutely untrue to say you can contract out of your liability in every state and territory in Australia. The circumstances will turn on what it is. In common law, it's one big picture of liability, so it's just 100% carved up. In safety law, everyone is on full liability. And if there is a knowledge of risk which you do not address as a principle, you will be liable. So can we just get rid of it? Because it's driving me crazy, and I read article after article of people who misrepresent what the basic law is, and the basic law is uncontroversial. Okay? I've got.
Okay, moving on to the next one because
we're
running out of time.
Running out of time. Okay, well let's. Sorry, I was pretty upset about that.
I think this one was just like a very obvious one. When you are consulting for redundancy, the obligation is to do it as soon as practical after you've made a decision. In this case, they made a decision and waited 3 months later to tell and consult. Wasn't really a consultation.
After they'd also denied him a job during that process.
Yeah.
So this is one where the Commission just looked at it and saw totally through it.
Yeah, so you do need to be careful in terms of if you're still doing preliminary discussions, haven't yet decided, make it very clear that no definite decision has been made. But once you've decided to implement a restructure, you have to start that consultation process. Okay, on to the next one.
Let's look at some bullying cases very quickly because they're alive. The first, we'll just need to get that heading to move on. There it goes. It's rapidly found. A tradie was found guilty of 2 Crimes Act breaches. They weren't
very bad bullying.
Yeah, they were putting kids' head in the noose and making them feel it. They were doing all sorts of horrible things. The interesting part of this was not that somebody was charged under Crimes Act and other offences, which was the individual who did this to the kid, but the organisation previously been charged by
prosecuted. Yeah,
so can I just say to you, and then we've got another case that comes straight after it, where once again there's been charges laid around bullying. Both of these are in Ballarat. I don't know why I grew up in Ballarat. It wasn't that bad when I was there, but what we are seeing, I guess, is regulators laying regular charges of breach of psychological hazards. They're choosing the egregious ones at the moment, so we're seeing ones around bullying. This is the reminder to everybody that the more diffuse versions, the more leadership ones are in their sights and will be coming soon.
Yeah.
That's 2 bullying charges laid and pleaded on within the last couple of months in a regional town. Okay, I think we're going to our last really big case, and I think Nina, you and I have got some. I think you've got some really interesting views around this case.
Yeah.
But no, it's right to disconnect. Can I just deal
with this? Is what you've been waiting for.
Look, it's funny enough. There's all these submissions being made, and the Commission has come down where they were a few months ago and saying this is an employee right rather than an employer obligation, effectively.
Yeah.
So
there's no positive obligation. They've made that clear on employers.
So, can we say that one more time loudly? Because the alarmist, Chicken Little, who's bringing the sky down out there, says the world's over. People are allowed to do this. And well, no, you can bring an adverse action based on not being allowed to disconnect. But if you have the right contracts, if you behave in a disciplined manner, you just don't have risk. Yes. Every time you get a general protections, it'll be thrown in because it's got a nice taste to it.
But how is it going to succeed? Because the obligation is not for them not to contact you. It's that you have the right not to respond.
Yeah.
So I don't understand how you prove that.
Well, I think it's where they don't respond, then you discipline them for not responding. That's where it'll.
But like if everyone's just shoving in, there's got to be proof.
No,
of that. Yeah.
And so if you can show it's part of the job that there is a need to contact that afterwards, your contract refers that, your policies talk about it, and there is a practice that exists that's reasonable, you can never be hurt. It's bullshit.
Yeah.
But it's another one where firms across Australia have thought, oh, this is a good way to get some work.
But it's exactly the same thing.
But nothing's changed. Yeah, so anyway, can we get rid of that? Because I'm sick of that one as well. All right, levels of frustration are growing thick and fast here. But this is a fantastic case, okay? Because this, can I just say, this is a case with FedEx. I'll talk briefly about what it says, which is if you rely upon a ground to reject a flexible work application, you will need to have some evidence in which to support that. And if a person raises an issue with you based on their personal circumstances, you will need to consider those personal circumstances against the needs of the business. And it is an evidence-based process. It is not an assumptive process. But it goes a bit further than both of us expected it, didn't it, Nina?
Yeah, like, I mean, I'll just very briefly talk about the facts because we're running out of time. But this went for several years, and it had an employee who had a very high needs family, 2 teenage children, and a wife who were autistic and needed basically constant care. So the employee wanted to work from home and had been during COVID. Put in work from home requests, and some of them were accepted, some of them weren't, but it was a back and forth as to what he could do. Basically, any arrangement that was accepted, he would just take paid leave, so he wouldn't have to go into the office. And it reached a point where FedEx was forcing people to go back to work, and they were trying to negotiate with him, and he brought a claim with the Fair Work Commission and asked them to arbitrate. During that process, they directed that he would work from home for 3 days and 1 day in the office, and he just ignored that and said, I'm just going to do my own thing.
Commissioner wasn't impressed by that.
No, which I think is an important point, because the Commission said that irrespective of whether the employee is happy or not, until an arbitration decision has been made, they are obliged to comply with the lawful and reasonable directions of the employer, just as if that is in effect.
So can I just say that is a really important part of this case, because that is your first piece of leverage.
Yeah.
Okay. But what happened afterwards is that when it came to the arbitration, FedEx sort of looked like they'd done the reasonable thing. As I looked, I thought
they had definitely negotiated and were trying to talk to the employee, ask for medical evidence, ask for more information. We're trying to accommodate him.
But what they didn't do, and this is the heart of it, is they didn't deal with the personal circumstances accurately that they were aware of, and more importantly, they failed to evidence the grounds upon which they relied upon, and that was the heart of it. Can I just say to you, there are simple ways of doing this, and trying to be too smart by half and throwing all the grounds up and then only being able to evidence 1 or 2 doesn't help you. Pick your grounds, pick your evidence, rely upon it, have documents that demonstrate that simply, and give the lawful and reasonable direction. Great case.
Yeah,
absolutely.
I would seriously recommend you read it, because they give really good examples of what reasonable business grounds would have succeeded, and it had FedEx relied on that instead of, they call them generic HR reasons, then I think they would have succeeded. But a really good case, because you're going to start getting a lot of these claims, and if you aren't, you know, documenting the processes and actually having evidence to substantiate your reasons, even though some of them are future stuff like we discussed, you're not going to succeed.
Yeah. So great case. Why don't we get on to our case study? We're running a bit late, but we're going to go over time.
Main topic.
Yeah, main topic. Woo. Okay, well, the main topic is pretty interesting. It's about officers. Officers are people who have control or substantial control over a business. People like CFO are necessarily officers, as are company secretaries. People who are head of operations of a multi-plant business are not. So it is someone who has a capacity to affect the operations of a business. You must identify internally against the legal definition who are officers. For your insurance processes, for officers and directors liability insurance, you must identify them. You must identify them for safety and corporations law. Fortunately, they are the same. But it is a deliberate exercise you must do, and the board must sign off on. That's step 1. 2, officer liability is different between Victoria and other states and territories. Officers' liability under Section 144 in Victoria is one which is a subjective knowledge of a particular risk and the requirement to use reasonable care to prevent it. But what is subjective knowledge is one which can be drawn from community knowledge. So it's not just objective, it's one that the person should know about that exists, like psychological hazards, can I say, is a great example.
So obvious known risk.
Yeah. But it is most definitely a risk that has been brought home to you. And in the reporting processes, you should have when a risk becomes alive to you, you must be satisfied then, as if you were in a WHS state, to apply the 5 elements of what is due diligence. Because in Victoria, there's no clarity around what your obligation is. Once you are alive to it, you just got to exercise reasonable care. And the definition of what that is looks to be what Section 27 is elsewhere, which is to know the nature of the risk, to know what the systems are that are in, ensure there are good systems in place, they're suitably resourced, to stay abreast of the most current law that relates to those. So, and then have an audit process that satisfies you that is occurring. So what I want to say is this: everywhere else but Victoria, it is stuff you ought to know.
But also, we are not saying that means that as a officer in Victoria, you should be ignorant to things, because you will also get in trouble.
No, and you can't be blind to it. So you can't know of a risk but say, look, don't tell me about that.
Yeah, like you can't choose not to get reports on safety.
That's right. So don't do that. But I guess what I'm saying is the difference is not as big as people think it is, because it does involve actual knowledge in Victoria, but actual knowledge includes the knowledge that you obtain as a human being living in an environment. You can't ignore it.
Yeah.
In Victoria and in WHS, officers are being prosecuted where they participate in the wrongdoing. But officers have now been prosecuted on 2 occasions where they were simply officers and were not specifically aware of what was happening.
Yeah.
Sorry, that's not true. Where officers did not participate but were aware of the risk and did nothing about it. Okay, so
they ignored it.
Yeah. So there are 3 levels of risk and prosecution in WHS. You participated, Victoria. You were aware of a risk and did nothing about it, Victoria, and WHS. 3, you weren't aware of it, but it was a known risk and the organisation did nothing about it. Won't be liable in Victoria. Remember, in every one of those first 2 examples in WHS, you are liable, but you are liable in WHS on the 3rd example. So what is the answer behind all this stuff? To actually have a proper safety system, to educate your board regularly around safety and the relative risks you have, and to ensure there is suitable resources to make sure the system has integrity. And then all of it has gone, okay? You don't have to worry about it anymore.
But also to educate your staff. Like, you'd be surprised how effective it is when we're doing training and explaining to them their actions on officers and liability and everything as well.
Yeah. Look, it is disturbing in a way that people are trying to protect officers from knowing what the truth is of their obligation. But what I do want to say is individuals are being charged much more frequently and officers are being charged much more frequently for much more serious offences, and so are organisations being charged for much more serious offences, and the regulators also charging for multiple offences, including individuals, which it didn't do before. So it's coming at you at enormous speed. So part of the reason we want to chat about this is be clear who officers are, be clear what the responsibilities are, be clear what you need to do, and be clear on how to fix it. It's not hard.
Yeah.
Okay, let's just jump now to the very long case study that I wrote in the early hours of the morning. Over to you, Nina.
Angel was no angel. She was an apprentice Sparky electrician for Lights On Nobody Home, LONH, a major electrical contractor to the volume home builder industry. Angel was clever. She'd woven her way onto her boss Kevin's heart and could do no wrong. It made her feel untouchable. Her conduct to others reflected this confidence. There were 5 apprentices who worked for LONH and 6 fully qualified electricians.
It should be 15, by the way.
There were 15 apprentices?
There was 15,
okay.
Yeah.
They would, maybe 10 of them quit.
Yeah, possibly after this.
They would hit a house in groups of 3, 2 apprentices and 1 qualified electrician, to undertake the wiring and electrical automation, complete it to lock-up condition for the electrical work, and then go out to the next house. Kevin would then attend and sign off completion. Barry was a small young man who was obviously shy. His parents were protective and part of a devout religious group. He was open about this and proud of who he and his parents were, but he did not judge or seek to
This is the word I put in for you.
Proselytize.
No, I just did it to you. I know. I've got to stop doing it.
I've got bullying complaint ready to go. His parents were kind and good people, but unquestionably raised Barry in a protective and naive world. Barry was not worldly, struggled with what his parents described as vulgar conversation, and withdrew from the day-to-day banter early on at a young age. Construction sites are not for the guileless. Barry was teased by the boys, but eventually found a kind of equilibrium with them. They toned it down a bit, liked him as he was a hard worker, was very honest, and in a weird way to them could be very funny. But Angel was different. His acceptance by the boys made her taunting and teasing more aggressive and hurtful. She started to call him by the moniker of the Virgin and could not use his name, which hurt and offended him. She said things like, "Get the Virgin to do that, you okay with working with Virgin?" And it went on. A few of the boys approached Angel and told her to cut it out. They explained, yes, he's innocent, but he's a good kid, and what she said hurt him. She laughed. She said, "Doesn't he want to be a man?" Damien, one of the qualified Sparkies, approached Kevin and said they had tried to stop what Angel was doing, but it just emboldened her. They liked Barry, acknowledged it wasn't easy because he was so proper. Damien explained they had reached a place where banter did exist with the boys Barry felt safe with, and he showed he liked being part of their team. But Angel's repeated denigration of him by the title Virgin really hurt him. He said to Kevin it was pretty obvious that Barry was hurting and starting to isolate from the team, and he'd seen him crying. He had started to miss a few days, which is not like him at all. The boys had stepped up and were supporting him, but Angel was just killing him, and the boys couldn't stop her. When they tried, she was worse, not only to Barry but to them. The next day, Barry's doctor wrote a private letter to Kevin explaining Angel's conduct was harming Barry. He was now suffering significant anxiety and he'd stopped eating and sleeping properly. And the doctor suspected that Barry was starting to slip into depression. Kevin was an old fashioned Aussie guy. He thought it all sounded a bit soft and weird. He spoke to Angel at work, shared the letter from the doctor, and asked for her view. Angel said he's just a weak religious nutter and doesn't like women. This is just pathetic. Kevin told her to cut it out and give him a break. She just laughed. Shortly after she sought out Barry in the warehouse, she came up to him and said, "I see you now go to your doctor to tell tales of me, little virgin boy. You are weak as piss. Even your doctor thinks you are mental. Are you fine?" Like these lines going. Barry burst into tears. She stood her ground, hands on her hips, and laughed. He fled from the sight to the chorus of derisive comments and laughter. He ran out the gates into the busy traffic on the main road outside and was struck and killed by an SUV. Gosh, that was long.
It was long, wasn't it? Yeah, and it had a lot of spelling mistakes. You can tell it was from me. Okay, did Kevin breach privacy law? If it was a breach, was excused by safety law?
Yeah, so you're supposed to use personal information for the purpose it was intended, which was just to notify him. So it would have been a breach of privacy law.
Yeah, unquote. By the way, we haven't got this here, but there's absolutely no doubt. It's just there's no claim that can be made because the young boy is dead. There's general protection. There's discrimination law. There's a whole lot of other breaches. I'm not talking about those. I just want you to know they're live. Did Kevin, as the managing director, have any liability under safety law, and if so, why?
Yes, because he was aware of the risk and he ignored it.
Yeah.
So both as an officer, so he's got industrial manslaughter risk because he's negligent, and also reckless endangerment because he was indifferent to the risk.
Yeah, and the industrial manslaughter part particularly plays out because the death was off-site, so no other, the reckless endangerment, it's interesting, may not be able to apply because the death occurred outside of work, but the fleeing did, so it probably is enough. Does you understand? So reckless endangerment lies where the death occurs in the workplace.
Oh, gosh.
Yes, whereas industrial manslaughter can apply even where the death is outside.
Could they pursue, I know we're running out of time, but could they have pursued, even though he died, that he was seriously injured before his death?
They could, and that's great. That is exactly the argument they could have done because reckless endangerment and all the other primary duties don't have a causation base. Okay? So just to make, because we are running out of time, but causation means that the offence relates to the action that occurred, and the only causation-based offence is a duty-based offence of gross negligence, which is industrial manslaughter, okay, which talks about the category 1 offences, which shows the complexity in WHH's test. Anyway, that's by the by. Did the company have any safety liability? Absolutely, they would have been liable to the fullest amount. What should have Kevin done after Damien spoke to him? So Damien was the one who came and said, look, she's doing this. We've got to this stage. What should have Kevin done?
Suspended her.
Yeah.
Investigated and then disciplined her.
Yeah, unquestionably. What should have Kevin done after he received the letter from the doctor?
He should have put controls in place to ensure that Barry was safe, including like doing the discipline and everything, but also making sure that there were controls, like going back to the doctor for fitness for work.
But what he shouldn't have done is actually show the letter. But it was it was a trigger that told him at that stage there was a significant risk to Barry, and he had to deal with Angel, and just telling her to stop it was not a sufficient control. In reckless endangerment, in industrial manslaughter, in duties,
like
it was
minimum
not enough.
should have separated them.
So there you go. We're only about 7 minutes over time. We've done very well, but it was a really big week this week, and we've had a lot of examples of rubbish being published that needs to be corrected, because our safety people out there are confused by it every day. So thanks for listening.
Give us a thumbs up.
Give us a thumbs up. And for those who said those things, don't throw stones at us, because that would be a breach of a safety duty.
See you next week.
See you later. Bye-bye.